Hello, everybody. Thanks for coming on this beautiful day. It's a gruesome story, and I haven't had... It's a gruesome story. I haven't had the opportunity to give a talk like this before, when I can cover the whole gamut of what's happened in my life in the last 10 years. But you'll see that virtually every single authority who is supposed to protect the public against wrongdoing by the banks have failed. And as was just mentioned, I'm in the process now of taking out a private prosecution against the bank and various solicitors for conspiracy to defraud. But I'll get to that during the talk. So I was employed by a firm called Waitmans, who are a nationwide firm of solicitors. Their head office is in Liverpool, but I worked in the London office just up the road here on High Holborn. And I started in the law in about 1982, I think, after I'd left Royal College of Art. A friend of mine was a partner in a firm who gave me a job. I started working in the post room, and never thought I'd end up working in the law for 25 years. But it was when I started in that firm, I started acting for John Lewis Partnership, doing their debt recovery and liquor licensing. And John Lewis are a very ethical company. They treated their debtors very fairly. And I had a very good relationship with them. I moved to 2 different firms in my career, and they followed me. They brought the work. I took the work with me. Then, in 2003, John Lewis sold their accounts package to HFC Bank. And the firm, Waitmans, had never heard of HFC Bank, and I expect many of you here won't have heard of HFC Bank. It's originally an American bank called Household Finance Corporation, and they specialize in subprime lending. So John Lewis... is that better? Yeah. So they specialise in subprime lending. John Lewis sold the whole accounts package, I think it was for £750 million. And then the people I dealt with in the credit department of John Lewis, they all lost their jobs and made redundant and so on. And I had a meeting at HFC's head office because I was worried I might lose the legal work. And I was told that, of course, they already had solicitors acting for them, and that was a firm called Reston's, who are based in Warrington. And their solicitor at this meeting, Duncan Hamilton, said to me that we could carry on doing the legal work for John Lewis, provided we did it on the same basis as Reston's. And I asked him what that basis was, and he explained the contract terms. And I said to him, but that's illegal. It's what's called contingency fees, which I'll go on to explain. But the contingency fees have been illegal in this country, I think, forever. In America, it is legal. So I think HFC bought their contract terms from America and then found some British lawyers who were prepared to act on that basis. One other thing Duncan Hamilton said to me, which is a bit of an aside, but it's very interesting. At that time, in 2003, I had never come across PPI, Payment Protection Insurance, which they sold when they gave a loan to somebody. And I said, what is that? How does that work? He said, oh, it's marvellous. We never pay out under PPI because people buy a policy to protect them in case they lose their job or they become sick, and they pay monthly. And the chances are, by the time they've been made sick or lost their job, 2 months have passed, and they've missed 2 months' payments. So the policy's invalid because they haven't kept up the payments. We never pay out under PPI. I mean, a few years later, HFC were fined over £1 million by the FCA for mis-selling PPI. But that's an aside. So I told him this contract was illegal. The senior partner of Waitmans was at the meeting as well, and on the way back to London, I told him, you're not supposed to be doing it like this. So basically the first thing that happened at Waitmans was they put a partner in Liverpool called Andrew Cox in charge of the whole project. He took it over, and his first thing to do was bring in his wife to take my job, basically. His wife had no experience in that field, but she was brought in to handle the contract. And it was Andrew Cox who called me Mr. Ethical, because I kept complaining about the contract. You shouldn't be doing it, it's illegal. Here's Mr. Ethical again. He was not happy with me. So basically what happened at Waitman's was they made my life hell. They took all the work away from me. They took it up. I had a team in London of 5 people, and they made all my team redundant, took all the work up to Liverpool. Now that's not the one I was expecting. Yes, it is. Yes, it is. I don't expect you to read these slides. They're really for an memoir for me. But this is an email that I sent to all the senior. I've redacted this, but I've obviously got the original, which I sent to all the senior management at Waitman's. At the time, I was off work with stress because of the situation. I specialised in bankruptcy, and I was not prepared to bankrupt people on the basis of illegal charges on debts, and I refused to do the work. So there was this standoff. I was at home with stress. They were carrying on. And this is an email I wrote to them, basically saying, I've told you all along that this contract is illegal. You've always said it's not illegal. And I've set out here the 3 reasons why it is illegal. And I say, I know this is a pain, but as I've said, the whole culture is making me ill, and you have to take it seriously. This was in 2005, so it was about a year after the contract was fully in practice. I didn't get a single response to this email. Not one of them replied to me. But that gives I have extensive evidence of me making complaints within the firm about what they were doing. After a year of being off with stress, well, in the December, they were paying me full pay, but apart from December, which is Christmas time, they didn't pay me for some reason, probably because it was Christmas. But I said to them, I want to come back to work now. So they said, well, we need to get an assessment, and they sent me to a Harley Street psychiatrist to assess me. I'm told that's common in whistleblowing cases. They try to discredit people's mental health. So I went to see this in February. I went to see this psychiatrist, and then I heard nothing from Waitman's for about 3 months, and I kept emailing them saying, have you had his report yet? I want to come back to work, and they kept denying having had the report. Eventually they had the report and sent me a copy, and the report was dated the 7th of February, and my appointment with the psychiatrist was the 6th of February. And his email address was on the report, so I emailed him and said, can you tell me when you sent the report to Waitman's? He said, well, on the date that it is on the report, 7th of February. And the report said that I like to quote this, that I'm a highly intelligent professional person that had all the facts at my fingertips, and that they should take me back to work as soon as possible. Well, obviously that didn't suit their purposes, which is why they sat on it for about 3 months. And when I realised that this is what they'd done, it was at that point that I decided to report them to the Solicitors Regulation Authority, because it was obvious that they weren't going to do anything to change what they were doing with the contract. So that's where all my troubles start, really. I'm not a plane spotter. That very jet is owned by the senior partner, or the owner of Reston's. His name's Christopher Reston. He lives in tax haven, Andorra, and he flies, well, I think he's sold this jet now, but at the time that I'm discussing, he flew from Andorra to the UK to run his business in Warrington. There are 5 solicitors at Reston's. They specialise in debt recovery. How on earth can he afford a lifestyle like that? You might wonder. It's I don't know whether Reston's have been doing what was illegal for other clients, but I do know that Andrew Cox, my boss, said that he wanted to market the business model, as he called it, to other clients, because it's very good for the bank, because the way it works is Waitmans or Restons, they pay all the fees, all the court fees. The bank pays not a penny in the debt recovery. So the way it works is the contingency fee part of it is, suppose the debt is £10,000. John Smith owes £10,000. The bank sends the details of the debt to the solicitors overnight electronically. The solicitor's software immediately adds 16.4% onto the debt. So on a £10,000 debt, they'll add on £1,640. 16.4% sounds odd, but it's actually 14% plus VAT at 17.5%, which comes out to 16.4%. So then the solicitor's software automatically generates a letter to John Smith saying, you now owe £10,000 plus £1,640. So they've charged £1,640 before they've done any work. And even that letter is automatically generated. So they haven't really physically done any work at all. Now that charge, that 16.4%, follows the debt right through its life. And what makes it illegal? Well, in fact, it's also against solicitors' rules for a solicitor to write to somebody claiming costs to which they're not entitled. And in that rule, in the solicitor's rules, it actually gives us as an example. For example, if you're recovering a debt, you must not add the cost of writing the letter. Well, they were adding £1,640 just to send that letter. But the other illegality about it is if the debtor said, well, I can't pay £10,000, but I can pay £5,000, then the fee becomes £800 and odd pounds. So it's a 16.4% of everything they recover is illegal. In America, it's fine. If you break your leg and a solicitor acts for you, say, I'll sue, I'll take 20% of the winnings. That's what happens in America, which is why American litigation is so enormous, why they claim for millions and millions of pounds, because the lawyers get their 20% or however much. In this country, it's illegal. The law changed in April of last year, and they do now allow what's called damages-based agreements, where a solicitor can charge a percentage of the winnings. But you can't add it on to the claim in the first place. You can't just take £10,000 and add your percentage on at the start. You take your percentage from the winnings, so it will be 16.4% of 10,000. So it comes out of the 10,000. You can't add it on. So even if they were doing it now, it would still be illegal. So I made my report to the Law Society, as it was then, and at the time I made my report, the Law Society set up the Solicitors Regulation Authority, who, as the name implies, are supposed to regulate solicitors. Waitmans, after I'd sent the letter to the Law Society, I told Waitmans that I'd reported them. And strangely, I mean, because they took a long time to deal with any of my complaints or anything to do with me, but on this occasion, they got me into the office straight away and sacked me, or made me redundant is the terms they used. Because they said, I had no work to do anymore, which was true because they'd taken it all away from me. So they made me redundant. But obviously it was because I was a whistleblower. So I said to Waitmans, well, you're now making me redundant because I'm a whistleblower. I'm protected by PIDA, which is the Public Interest Disclosure Act. I'm going to take you to a tribunal and I'm going to screw you for damages because there's no limit on the amount of damages you can award a whistleblower. Normally the limit is £70,000, but in whistleblowing cases it's limitless. And I was advised by an employment lawyer that my claim could amount to about £300,000. But Waitmans suggested to me, offered me the opportunity of going to a mediation, which I accepted. In a way, I regret that now. But I knew that mediation would be much quicker than a tribunal, which would take a year. You see, the thing about the tribunal is it's public, and my grievance is about their illegal practices. It would have been in the public domain, so they obviously didn't want for that to come out. So we went to mediation. It was a very tough day, and in the end, did pay me a six-figure sum, just a six-figure sum. It just went over 100,000. And I signed a compromise agreement which contained a gagging clause, which I'm breaching today. Now, Waitman's act for the NHS and the Metropolitan Police, and I'm sure many of you know about all the scandals involved in whistleblowers in the NHS. They've all been gagged. I can't say Waitman's have gagged them all, but Waitman's are the experts at gagging clauses. They also act for various local authorities, including Wirral. And they had a production line producing these compromise agreements with the gagging clauses automatically included. Gagging clauses are ineffective in cases of whistleblowing because if they seek to gag somebody from disclosing unlawful behaviour, they avoid. So it's never really troubled me that I'm breaching the gagging clause. In theory, Waitman's could sue me and recover the money they paid me, but they haven't to date. So this money was paid, half of it was paid in a lump sum, and the rest was paid over 2 years. So I had an income, and I sold my house. I just bought a house after I'd won the contract for the firm, thinking my future was secure. I bought a house in Tottenham, the first time I'd ever bought a house. But within a year, I'd lost my job, which was very scary. So I sold my house in London, and I moved to Hastings, and I lived from the payments of my settlement money. But I ended up in Hastings. I ended up working as a consultant for a firm in Brighton, and I came across a claim form issued by Waitman's against somebody where they had still included the collection charge, and this was after the adjudication from the Solicitors Regulation Authority. This is an extract from the adjudication from the Solicitors Regulation Authority. You'll see that the panel were satisfied that this amounted to a contingency fee, so they confirmed it was a contingency fee, which is illegal. They then went on to say, however, the panel noted that this had happened in only a small number of cases, and that on behalf of the firm, Andrew Cox had, on behalf of the firm, renegotiated the contract with the client so as to ensure that any future agreement was compliant with the rules. The panel decided on the facts of this case to make a finding that Andrew Cox had breached Practice Rule 8, but to take no further action. A small number of cases. When I left the firm, to my knowledge, I estimated there was 70 to 80,000 cases worth over £100 million. A couple of years ago, I did a Freedom of Information Act request to the Ministry of Justice and asked them how many claims had been issued by Restons and Waitmans on behalf of HFC Bank. And these are the figures that they gave me. So I ignored Restons because I knew that Restons had other clients and it might have skewed the figures. But I knew that Waitmans didn't at that time. They were just acting in bulk debt recovery for HFC Bank. So if you look at the year, 2918, which is 206 to 207, they issued 2,981 claims through Northampton County Court for HFC Bank. Now, the average collection charge that they added on was £1,500. In some cases, it was over £5,000. But Waitman stated in Chambers, which is the standard legal directory of firms, they were bragging about how effective their debt recovery department is. And they said that they only issued proceedings in 20% of cases. Which makes sense, because if they're paying all the court fees and they don't get any money back from the debtor, they lose all those court fees. So they really would rather not issue proceedings. And their preferred method, especially if the debtor owned a property, was to ask the debtor to agree for them to put a charge on their property, effectively a mortgage on their property, and a lot of people went along with that. So if Waitman's only issued proceedings in 20% of cases, that 2,981 in that year is 14,905 cases. assuming that Reston's, because they always told me, the bank always told me they were going to treat both Reston's and Wakeman's fairly and give us equal amounts of claims, assuming Reston's also had that number of cases, that means that in that year between Reston's and Wakeman's, there were £44,715,000 worth of illegal charges added onto the debt in 1 year. Now, I think Reston's had been acting for the bank since the bank started business in the UK in the 1970s. So extrapolating the figures from that, the amount of illegal charges that have been added are over £1 billion. In about the same time that John Lewis sold their accounts to HFC Bank was taken over by HSBC Bank. That's a name to conjure with. They set up a company called John Lewis Financial Services. So the John Lewis accounts really had nothing to do with HFC anymore. They were HSBC. And HSBC have basically closed down HFC now. The chair of HSBC, Stephen Green, said that in retrospect, having purchased HFC was one of the worst decisions they ever made. And they're certainly going to regret it now. So where was I? So yes. So in that year, the HFC. So in my dealings with HSBC, they've always tried to offload the liability for this to HFC, but it doesn't work. If anybody's got a John Lewis card, if you look on the back, it'll say in the small print, John Lewis Financial Services, a member of HSBC Group. So that gives you, so if you recall, the Solicitors Regulation Authority said it only happened in a small number of cases. Well, in that year of my complaint, now the reason I chose that year, 2006, is the year I made my complaint to the Solicitors Regulation Authority. So a small number of cases was actually 14,000 and odd, because it wasn't, as I explained, it wasn't just the cases where they'd issue proceedings. There were, that was just 1/5 of the cases. 4/5 they agreed in installments or something with the debtor or made other arrangements with a charge on their property. The Solicitors Regulation Authority, if they have a fund called the Compensation Fund, and if solicitors act unlawfully, people who have been affected, victims of their unlawful practice, can make a claim under the Compensation Fund. Now, if my story was well known, there would be a massive multi-million-pound claim against the Solicitors Regulation Authority, which I'll call SRA. So that could be one of the reasons why they didn't take any action. Another reason may be that a member of Wakeman's sat on the Law Society panel, which could be relevant. But more recently, I reported Reston's to the Solicitors Regulation Authority because during my mediation, Wakeman's produced a statement in their defence. It was a foolish thing to do, but in their defence, they said, a bit like a child, a naughty child. They said, well, anyway, Reston's have been doing it on the same basis as us for a number of years. So I have evidence from a large firm of solicitors that Reston's, another firm of solicitors, were also adding illegal charges. So I reported Reston's to the Solicitors Regulation Authority. Guess what? Nothing happened. They tell me that they visited Reston's office and they were satisfied that they weren't charging contingency fees. I know they were because I've seen, when I was dealing with, when I was at Wakeman's, Duncan Hamilton, the bank's solicitor, gave me a copy of Reston's contract with the bank so that we could draft our own contract. So I've seen Reston's contract, and I know Reston's were adding 16.4% to the debts. Solicitors Regulation Authority didn't seem to be able to find that. So the Legal Services Board regulate the Solicitors Regulation Authority. So I went to them and with my concerns, and their first response was that this is a very serious matter and we will be looking into it. Well, what they did, they wrote a letter to the SRA and they said, we've had this complaint from Mr. Wilson, he's not satisfied that you investigated his report on Restons. What do you have to say? And they wrote back and said, yes, we did. So that's the end of it. It's fine. Nothing for me to worry my head about. Everything's fine. So, this is the extract from the statement made at the mediation. And you will see, this is a nice bit of legalese that Waitman's used at the middle of the last paragraph. We also pray in aid of the fact that the contract has been operated by HFC for a considerable period, and similar terms have been used by another firm, Restons. So there's the evidence. That was a statement made in a mediation. So I'm not supposed to disclose that, but I don't really care. There's an awful lot that I'm not supposed to disclose. But if I didn't, nobody would know about this, and thousands and thousands. I estimate 500,000 to 600,000 people have been affected by these charges. Right. This was fun too. Ministry of Justice. When I was working for the firm in Brighton, and I came across this claim form, realising that Waitmans were still doing it after I'd reported them. At the same time, the Consumer Credit Act was amended. The Consumer Credit Act 2006 came into force, and that has a provision to do with unfair relationships. So I realised that I could claim these charges back for people on the basis of the unfair relationship provisions in the Consumer Credit Act. So I decided to set up a business. I called it Nicholas Wilson Reclaims. But I needed to be able to contact debtors. I needed to be able to contact the people who'd been affected by the charges. So my first port of call was the Register of County Court Judgments. If anybody has a judgment against them in a county court, it gets put in a register, and that started in the 1850s. And it used to be a big ledger, and anybody could go to a court and look up. If you know somebody's name and address, you can look them up in the register to see if there are any judgments against them. Well, we live in the internet age, and that register is now administered by a company called Registry Trust Limited, who have a contract. They're a not-for-profit company who have a contract with the Ministry of Justice to administer the register. And they have an online presence. It's called Trust Online, I think. But it doesn't matter. You can now look up somebody's name and address on the internet, put in the details, pay £4, and you can find out if there's any judgments against them. Now, the biggest user of these records, county court judgment records, is credit reference agencies, Experian, Equifax, and so on, who buy millions of these records. And if you are a bulk purchaser, it's not £4, it's 30 pence or something for each record. So I thought I'd like to be a bulk purchaser. I contacted Registry Trust and said, can I have the records? When solicitors issue proceedings in bulk, they can issue them through Northampton County Court bulk issue section. And when they do that, they're given a whole range of claim numbers, which goes on the summonses. And embedded in the claim numbers is a code which identifies the solicitors, which firm has issued the summons. In the case of Restons, it's not rocket science for me to work out that in all the claims that Restons has issued, the letters XO were embedded in the claim numbers. So I knew that all claims with an XO in were issued by Restons. So I said to Registry Trust, can I have all the records from Northampton County Court with an XO? And they said no. Now, to me, this is equivalent to Smarties. If you only like red Smarties, I don't think it would be unreasonable to go to, is it Roundtrees that makes Smarties, whoever, I don't think it would be unreasonable to go to Roundtrees and say, look, I only like red Smarties. Can you sell me millions of red Smarties? They would. It's business. It's what business people do. Registry Trust refused to. All they had to do was filter. I mean, anybody that knows databases knows it's a very simple matter to filter a column to just give me that information. They refused to do it. And I'll explain why. The Register of County Court Judgments is controlled by a statutory instrument, which is a small act of Parliament. It's not a full-blown act. And in the this is an extract from the statutory instrument, and it says that anybody can search the register on these bases relating to a named court within a named county, or with the agreement with the registrar against such other criteria as may be requested. Well, that was my category. My criteria is, can you search it on the basis of an XO? No. Then it goes on to say, they can refuse it if they think your purposes are to breach data protection principles or provisions of any other enactment. That didn't apply to me. I wasn't breaching any other enactment. Finally, it says, where a refusal is made, the person who has been denied access or has been denied a search of the register may appeal to a county court against the decision of the registrar. So that's what I did. And I did it on the basis that I was confident, win or lose, that I wouldn't have to pay their costs, because they never told me why they wouldn't give me this data. I know they went to back to the Ministry of Justice and said, well, what about this? You know, should we give this guy this? And they said no. When this legislation was drafted, there was a memorandum published as well, which explained why they gave the registrar a discretion as to whether he could refuse somebody access to the register. There used to be companies called, they used to, credit repair companies. They used to contact people who had a judgment against them and say, if you apply to the court to set the judgment aside, it goes off the register and you can apply for a mortgage or you can apply for more debt and stuff. It was a scam. And understandably, the Ministry of Justice wanted to clamp down on that because it wasted courts' time. They weren't legitimate reasons to set the judgment aside. It was just a scam to get more credit. So they gave the registrar discretion to refuse people access to the register. And I think that the Ministry of Justice just assumed that I was like a credit repair company and I was going to fill the courts up with all these claims to get these charges back for people. Which is not true, because if I did any of these, and I have got money back for people, but I always went to the Financial Ombudsman Service because it doesn't cost anything. They're not terribly efficient, but it doesn't cost the debtor anything. And I have had some success with those. So, and also, before the hearing of my appeal, I heard nothing from Registry Trust for 2 days before the hearing. So I thought, this is great. All they want is a court order against them, so they don't have any liability and they can give me the information. But they lawyered up, and they got this barrister who their argument was, and I couldn't really argue it. Their argument was, I hadn't been refused access to the register. I could have had all the information, which is true. I could have bought all the records from Northampton County Court and filtered them myself, but I would have had to pay a deposit of £49,000, and I would have had to pay a similar amount of that each month. So financially, it was impossible for me to do that. But they say I hadn't been refused access to the register. They had refused to carry out a search according to my criterion, and that's not appealable. Now, that's a very specious argument. But on the reading of the Act, it's pretty cut and dry, and so I lost my appeal. And so their barrister then went on to claim their £5,500 costs. And I said, well, hang on a minute. I've got a letter here to my MP from Registry Trust saying if Mr. Wilson has a problem with this decision, he has to appeal it in the county court. So I showed this to the judge, and he said, sorry, no costs. So that was one small victory. I didn't have to pay £5,500 costs for losing. But it meant that I didn't have a business. And a very funny aspect of this is to run my Nicholas Wilson reclaims, I had to have authorization from the Ministry of Justice because I was a claims manager. And to have authorization from the Ministry of Justice, you have to pay a fee. And the fee is based on your income from the work you do. And each year, I mean, I had the business for about 2 years, I had no income. And so my fee should have been, I don't know, £100 or something. But they didn't believe me. And I would say to them, well, look, I don't have any income because you won't give me the data that I need to run the business. And I had to make a special statement, like a sworn witness statement, to explain why I had no income. And it was because the Ministry of Justice didn't give me the information. Now, them not giving me that information is in itself a major scandal because county court judgments are public domain information. Everybody is supposed to have access to it. It's like the electoral roll. It is just a record of judgments. They always claim the purpose of the registrar is for credit, to check people's credit, which is nonsense. Consumer credit only really took off in the 1950s when people started buying washing machines and so on. In 1850, when the register first came about, there was no such thing as credit as we know it today. So it has nothing to do with credit checks. And I should have had that information, but I didn't. So I closed my business. That's a reassuring logo, portcullis. And we know that represents Parliament. My MP in Hastings is Amber Rudd. She used to be a banker, and she's George Osborne's PPS. She hasn't really helped me very much, funnily enough. The Parliamentary Commission on Banking Standards, who were questioning all the banks last year, I sent them an email saying, can you please take this into consideration? They didn't respond. So I sent another one a week later saying, I'm concerned that you haven't responded. So they did look at my website, and I have a little spying software so I could see who's looked at my website and for how long. 10 seconds. Parliament looked at my website for 10 seconds, but they still didn't reply to my email. There are, I can't remember all the names now, but there are, well, one of the MPs that sat on the Parliamentary Commission on Banking Standards was Pat McFadden. I got in touch with him. He delegated it to one of his researchers, a young intern, I guess. And she said, well, what I'll do is I'll contact the Office of Fair Trading and I'll contact the Financial Ombudsman Service. I said, well, don't, because neither of those are regulators in the sense of what we needed to happen. And the Office of Fair Trading have already dealt with this. But she did it anyway, and they both wrote back and said, we can't do anything because we're not regulators. And so it was a complete waste of time. But on my website, there's a long list of MPs and Lords that I've contacted. Stella Creasy, who does a lot of campaigning against payday loans, no response. None of them. Margaret Hodge, who is so ruthless on those committees, no response. Nobody has touched it. But we'll find out why. Now, unbeknown to me, so bearing in mind, I told the bank in 2003 that what they were doing was illegal. They carried on doing it. Reston's carried on doing it. Waitman's carried on doing it. Unbeknown to me, though, the Office of Fair Trading were looking into this, and in November 2010, they made an order against HFC Bank telling them to stop adding collection charges to accounts. So 7 years after and multi-million pounds after I'd told the bank what they were doing was illegal, they were told to stop doing it by the Office of Fair Trading. Now this gets very interesting. That is, you don't need to read it. I'm showing you this to show you how it might have been possible to have missed the Office of Fair Trading order. This is a press release they issued in November 2010, dated the 22nd of November. Remember that date. Now, this is about OFT acts on concerns about charging orders. Well, charging order is when a charge is put on your property if you owe somebody money. It's nothing to do with collection charges on debts. right at the bottom here is a PDF. And that PDF is the order against HFC to telling them to stop adding collection charges. Remember the date, 22nd of November. The date on the order against HFC is the 17th of November. So a week later, they did their press release. That's the date of the order. On the 16th of November, the day before the order, this man, Stephen Green, chair of HSBC, was made a lord by David Cameron and invited into Parliament as a trade minister. So the OFT, it seems, it might be coincidence. I'm not a conspiracy theorist, although if I was, I wouldn't believe what's happened to me anyway. It might be coincidence, but the OFT order was dated after, one day after he'd been made a lord, published a week later, and hidden away on a press release related to something completely different. So nobody knew about it. I did, because I'm on their case, but nobody else. It wasn't reported anywhere. Incidentally, and this is interesting, the OFT also made an identical order against American Express. They were also adding charges, and I've also got money back for people from American Express. But I have obviously no inside knowledge about how they operated. City of London Police. I have contacted them in the last year. City of London Police regulate the City of London, and as many of you will know, the City of London is a world of its own. It has its own rules and so on. And the City of London Police is funded by the City of London, and the City of London is funded by banks. I reported all of this to the City of London Police. I'm in a group called Whistleblowers UK and another group called The Whistler. So I have contacts with lots of other whistleblowers, and through those contacts, I got in touch with a retired fraud detective who also had a friend who was a fraud detective in the City of London Police. And both of them privately, unofficially, looked at all my evidence and said unequivocally it's fraud. And I think most of you will agree that it's fraud. First of all, it's conspiracy to defraud, which is not a statutory offence, it's a common law offence. But in the Fraud Act 2006, there are various definitions of different kinds of fraud, and one of them is abusing your position. If you write to a debtor claiming £1,640, which you're not entitled to, and the debtor has no legal representation or knowledge, you are abusing your position, especially if you take that money from the debtor. It's theft, and it's fraud. City of London Police did nothing. Why? Oh, well, the Solicitors Regulation Authority have looked at it, the OFT have looked at it, the FCA have looked at it, and I'll come on to the FCA in a minute. They have done nothing, so why should we? That was basically their response. So I am now in the process. I sent some more papers to the City of London Magistrates Court on Friday. I am taking out my own private prosecution against Douglas Flint, who is the chair of HSBC Holdings, Ian Evans, who's was the senior partner at Waitmans, Patrick Gall, who was the managing partner at Waitmans, Andrew Cox, who was my boss, and the pilot, Christopher Reston, who flies that plane. I've charged them all with conspiracy to defraud. Various individuals also I've added on for good measure, various other fraudulent things, abuse of position, and not disclosing facts is another section in the Fraud Act, and I've alleged that against Duncan Hamilton, the bank's solicitor, because he was the one that drew up the terms and conditions of the consumer credit agreements. And all the consumer credit agreements say about costs is if you default, we will charge you reasonable costs. That's all it says. Now, those are not reasonable costs. They are, apart from anything, apart from the illegality that I've discussed, they are in breach of Office of Fair Trading guidelines on debt recovery. You are not allowed to charge costs that are not related to the work you've done in recovering the debt. So I haven't really got any more slides connected to the City of London Police because they didn't do anything. Nor did these people. The FSA, as most of you will know, the Financial Services Authority, became the FCA. When they were the FSA, I made a report to them in December 2012. I reported this fraud to them. HSBC, HFC. Heard nothing. Over the following year or so, I would phone them occasionally. They have what they call a whistleblower hotline, and I reported it through the whistleblower hotline. Nothing. They did nothing. They did nothing. So recently, beginning of this year, I did a Freedom of Information Act request, I like those, to the FCA saying, what have you done with my complaint? The first thing they said is, they didn't reply in the statutory 20 days. They said, we can't reply just yet because we have to decide if it's in the public interest to reply to you. Okay, fair enough. But they did reply. And this is the most shocking part of my story, and it's where I'll end. The top bit is an extract from the order that the OFT made against the bank. When recovering a customer's outstanding debt, until such time as HFC Bank has, after the date of these requirements, introduced a new term or terms in its agreements with customers, or varied a term or terms contained in the agreements with customers, pursuant to which it may levy the collection charge. So the OFT was ordering the bank to change their terms and conditions if they want to carry on adding a collection charge. The FCA, when they replied to my request, said we didn't take any action because the OFT have already dealt with this. And they said prior to 2010, when HFC sent an account to solicitors to recover outstanding debts, it added a charge to reflect the costs of the recovery. HFC's agreements with customers gave it the right to do this, and the fee was added after the customer had defaulted on the loan. So the regulator of the banks, who I had reported £1 billion fraud to, is telling me that HFC's agreements allowed them to add a collection charge, when in 2010, the Office of Fair Trading told them to change their terms and conditions because there was no provision for them to add a collection charge. So I wonder if the FCA had actually read the OFT order. It makes you wonder. So, oops, that's me. But to sum up, this fraud has been covered up by the Office of Fair Trading, by the Solicitors Regulation Authority, by the Legal Services Board, by the Financial Services Authority, by the Financial Conduct Authority. Who else have I missed? MPs, Lords. Oh, there's the media. I haven't touched upon the media. I worked with Private Eye for 9 months with a journalist from Private Eye who, well, one of the things he did, he wrote to Restons and he sent an email including a load of claim forms with the collection charge added on. And he said to Restons, can you explain these collection fees on these documents? And Restons sent a reply and said, thank you for your email. We have very carefully examined these documents, and unfortunately, we cannot see the term collection fee. We can, however, see the term collection charge, and we presume that's what you're referring to. That was their response. HSBC said to the Private Eye journalists, we stopped adding these charges in 2009. So if you look on my website, I have a claim form, John Lewis Financial Services, dated January 2010, with a collection charge added on. HSBC also said to the Private Eye journalist that it was our policy, it wasn't the solicitor's policy to add the charge. They're trying to remove it out of the solicitor's illegality so that they think it then becomes not illegal. But I have a letter from HFC Bank when I was trying to recover money from somebody, and HFC Bank said to me, it's nothing to do with us, you have to go to Restons because it's their policy to add the charge. So they're both blaming each other. But the bottom line is, Private Eye wrote a whole-page article, and then they withdrew it day before publication. It was never published. It's not, but I've published it on my website. They were furious with me, but frankly, I don't really care. They've never told me to this day why they haven't published it. And I suspect, and as I said, I'm not a conspiracy theorist, but I honestly believe that MI5 are protecting HSBC Bank, because Private Eye have been going after Stephen Green, the ex-chair of HSBC, for a long time. And they recently did a Freedom of Information Act request to a government department, which I can't remember which department it was. But when they got the response, it included, when you do an FOI request, there are exemptions where they don't have to give you the information. And the exemption that they were given is uniquely and only applies to the security services. And I was also told recently that BBC Panorama have looked at this 3 times. Moneybox Live are still interested in it. Radio 5 Live are still interested in it, apparently. Channel 4 Dispatches have looked at it and turned it down, but HSBC advertises on Channel 4, so probably not a good thing. But to date, Private Eye have never told me. Yes, so I was talking about MI5. So Private Eye did a Freedom of Information Act request, and they got that exemption back. And I was told recently that at the BBC, every news item is read by 2 people from MI5. I do think this fraud, if it is exposed, which it will be because I'm not going to give up, it will possibly cause public order problems. But it will certainly embarrass one of the biggest banks in the world, whose chair was a trade minister in Cameron's government. It will be deeply embarrassing because all the other scandals involving HSBC, which you will all know about, drug dealing in Mexico, the LIBOR fiddling and all that, they're exotic. I don't understand LIBOR. I mean, most of these things are very exotic and most people don't understand. They do understand. Well, can I go back with this? The other way. They do understand John Lewis, B&Q, Dixon's, Currys, PC World. HFC handled the accounts for all these companies. So if you bought a computer from PC World and defaulted, they would have added a collection charge. If you bought a washing machine from Currys, the same applied. B&Q... okay. I've finished now, really. But what I'm really trying to say is, this is not exotic. This is just theft on the high street, and it's HSBC Bank, and you'll hear about it soon. But I think on that point, I'll stop.